Tenemos problemas con el doctor Alejandro Cabello, que no ha podido ingresar, pero ya se está conectando.
Aquí en México el internet falla mucho.
Pero él me dice que es la liga, ¿no?
Ah, puede ser también. Pero yo tengo conozco muchas personas que tienen problemas con su servicio de internet.
Pero si toca es no entrar faltando tan breve. Pedro, Nel, ¿le podrías activar el micrófono al doctor Alejandro? Ya estamos.
Listo. Buenas tardes. Una disculpa por la demora, no podía entrar, no sé por qué, pero ya se pudo.
Doctor Cabello, cuando usted disponga, podemos iniciar.
Empezamos de una vez, ya que han pasado 3 minutos.
Perfecto.
Muy bien. Bueno, pues muy buenas tardes a todos y a todas. Agradeciendo nuevamente su asistencia al tercer seminario organizado desde el proyecto del cual soy director y que estoy encabezando. Agradecemos también la organización de estos seminarios a través de Guillermo Villamizar y la presencia de cada uno de ustedes, así como de nuestro ponente del día de hoy. A manera de iniciar y haciendo dando un breve contexto, pues también al equipo de traducción, un agradecimiento también muy especial por su trabajo. Para dar un contexto de lo que van estos seminarios, pues surgen a partir de un proyecto de investigación en el cual lo que se pretende es abordar un problema de salud desde diversas aristas, desde diversas perspectivas, con el objetivo de crear un proyecto de investigación y de incidencia. De lo que va esta propuesta en general se puede resumir en 5 puntos, los cuales son el monitoreo ambiental de la contaminación por asbesto en una comunidad de la ciudad del norte de la Ciudad de México, en donde se estableció durante muchos años una fábrica de asbestos dentro de un corredor industrial, dejando una contaminación tanto ambiental como ocupacional a los habitantes y trabajadores de este lugar. Consecuentemente, pues, aparecieron problemas de salud relacionados a esta exposición y en resumen, los problemas que se han presentado han sido diversas enfermedades relacionadas con la exposición al asbesto y principalmente el mesotelioma maligno pleural. Es por ello que desde la Unidad de Investigación de Salud en el Trabajo del IMSS se inició hace cerca de 15 años una propuesta de investigación para la detección temprana de esta enfermedad, para así poder ofrecer mejores opciones terapéuticas a las personas que desafortunadamente contraen esta enfermedad. En sentido amplio también de este proyecto se ha incluido para este propósito y para darle cabida a otras perspectivas, una parte de políticas públicas y de legislación en la cual lo que se pretende es conocer el estado de las normas y reglas que regulan en México y a nivel mundial el comercio y el uso del asbesto, para así poder plantear desde México una prohibición del uso del asbesto. Este esfuerzo ya se ha hecho anteriormente por parte de la doctora Guadalupe Aguilar y sus colaboradores. Sin embargo, ahora creemos que puede tener mayor fuerza uniendo esfuerzos con diversos académicos y académicas, así como personas que se han incorporado a este proyecto de investigación fuera de la academia. Asimismo, también tiene una parte este proyecto de organización y educación, una parte pedagógica y antropológica en la cual se van a explorar diversas estrategias para promover la salud en la comunidad y finalmente fortalecer la capacidad de estas comunidades que se encuentran insertadas en corredores industriales para contravenir los efectos de la contaminación ambiental en la salud. Todo esto se pretende registrar y se registrará en un material audiovisual que estará disponible, esperemos, al final de este proyecto para diversos públicos, pero principalmente para el público en general, ¿no? Para crear una conciencia y una pedagogía referente a las contaminaciones en corredores industriales. Agradezco nuevamente su presencia y paso a darle la palabra a Guillermo Villamizar para que presente a nuestro invitado del día de hoy, a doctor Barry Castleman, que le agradecemos mucho y estamos muy honrados de su presencia en este día. Muchas gracias.
Muchas gracias, doctor Alejandro Cabello. Esta noche, pues, contamos con Barry Castleman. Durante su presentación, el doctor Barry Castleman nos actualizará sobre los últimos avances de la justicia italiana contra Stefan Smith Heine, el propietario de la multinacional del asbesto cemento de Eternit, y la voluminosa literatura publicada sobre la letalidad del asbesto, planteando la pregunta: ¿qué sabía la industria en ese entonces? Debido a la importancia de esta pregunta para determinar la responsabilidad corporativa en los Estados Unidos, se ha realizado un esfuerzo considerable para investigar el asunto durante los últimos 40 años. Un extenso descubrimiento legal previo al juicio ha sacado a la luz una extraordinaria variedad de documentos corporativos que reflejan el conocimiento y las acciones de empresas individuales, tanto antes de la era de la regulación, que comenzó en 1970, como después, a medida que aumentaban las presiones regulatorias y de los medios y las demandas por los daños. La figura de Barry Castleman en el movimiento internacional contra el uso del asbesto es emblemática. Su aguda visión para desentrañar la agenda oculta de la industria del asbesto por esconder sus crímenes corporativos ha sido de valiosa ayuda para entender los procedimientos de la industria que busca eludir responsabilidades. Sus investigaciones sobre el desarrollo histórico de los valores límites de riesgo, la dosis respuesta frente al nivel de exposición o la biopersistencia, han revelado serias deficiencias en el proceso seguido por las autoridades encargadas de ejercer control a las industrias que emplean sustancias tóxicas en el ambiente laboral. Estas investigaciones han sido de una importancia extraordinaria para la seguridad laboral, y estos mismos hallazgos han probado su pertinencia en escenarios políticos donde se discuten las agendas de prohibición del asbesto, porque sus revelaciones prueban que los argumentos de la industria se inspiran en la mayoría de los casos en el fraude científico. Como bien lo dice David Michaels, la incertidumbre es un problema inherente a la ciencia, pero fabricar incertidumbre de manera intencional es un asunto completamente diferente. ¿Qué sucede cuando el factor inductor de la enfermedad, como es el caso del asbesto crisotilo, produce daños en la estructura genética de las células causando cáncer, incluso si se permanece dentro del rango de las concentraciones que determinan los valores límites del riesgo? Las sustancias que causan daño irreversible, acumulativo y crónico a los órganos humanos de los trabajadores, difícilmente se les puede asignar límites seguros, mucho más si esos límites se definen a partir de exposiciones inadecuadas de corto plazo en humanos o animales. De acuerdo con Castleman, solo después de 1970, la medicina industrial en Estados Unidos empezó a contar con fondos federales adecuados para hacer investigación y de esta manera presionar para introducir regulaciones en este campo. Debido a la reticencia de los médicos para abordar los problemas relacionados con las enfermedades ocupacionales, fueron los ingenieros en higiene industrial y los toxicólogos quienes entre 1945 y 1970 llevaron esta vocería. Barry Castleman nos enseña que la metáfora del asbesto es también una herramienta interesante para comprender las lógicas del capital y su idea del progreso, amparada en ese concepto de la modernidad que le ofreció al hombre la posibilidad de usar su conocimiento para dominar las fuerzas de la naturaleza y construir un bienestar general. Sin embargo, el bienestar que nos ofrecen sustancias como el asbesto conlleva una preocupante deuda en términos de salud pública, ocupacional y ambiental, convirtiéndose en el precio que paga la sociedad por el desarrollo. Desafortunadamente, este costo lo terminan sufragando los eslabones más débiles de la sociedad, en este caso los trabajadores. Como resultado de los movimientos sociales en todo el mundo, el asbesto está prohibido en más de 65 países. Sin embargo, la mayor parte de la población vive en países donde todavía se usa el asbesto, a menudo con pocas medidas de protección o ninguna en absoluto. Ninguna otra industria tiene un registro de malas prácticas documentadas en salud ocupacional y ambiental como la del asbesto. Para hablarnos de estos temas, tenemos entonces esta noche al doctor Barry Castleman. Él es ingeniero químico de la Universidad Johns Hopkins con maestría en ingeniería ambiental con la tesis Efectos del asbesto sobre la salud y un doctorado de la Escuela de Higiene y Salud Pública de Johns Hopkins también con la tesis Casos históricos de estudio sobre la responsabilidad corporativa en las amenazas industriales a la salud. Ha sido consultor del gobierno estadounidense, de la Organización Internacional del Trabajo, del Departamento de Justicia de los Estados Unidos, de la organización Greenpeace, de la Comisión Europea, del Banco Mundial, de la Organización Mundial de la Salud y la Organización Panamericana de la Salud, entre otras agencias e instituciones de renombre internacional. Rindió testimonio de sus conocimientos sobre el asbesto y las consecuencias de su explotación minera, industrialización y uso en varias ocasiones ante el Senado y la Cámara de Representantes de los Estados Unidos. Su libro más conocido al respecto se titula Asbesto, aspectos médicos y legales. Una verdadera Biblia sobre este mineral para todo aquel que quiera profundizar en esta materia. Antes de cederle la palabra a nuestro invitado, queremos decirles que contamos con traducción simultánea en la parte inferior de su ventana a esta conferencia por Zoom. Y para la sesión de preguntas y respuestas les recomendamos que las hagan llegar por el chat de la misma conferencia. Bienvenidos todos, bienvenidos Barry. Muchas gracias por aceptar nuestra amable invitación. Y señoras y señores, con ustedes el señor Barry Castleman. Adelante, Barry. Vamos a presentar las diapositivas, ya las montamos, un segundo.
Before we put on the slides, okay, we'll put on the slides. I just want to tell you a little about myself. I was originally educated as an engineer, went into public health in 1970, 1971. I was trained in air pollution control in a master's program, master's degree at Johns Hopkins University. And at that point, I started reading about asbestos, and I couldn't believe how it was so totally out of control. This is 1970, 1971. New governmental agencies were just being created in the United States, the Environmental Protection Agency, the Occupational Safety and Health Administration. And so I was coming on the scene at the end of what I call the Wild West era of asbestos use in America. And eventually I wound up working with all kinds of environmental groups and government agencies. I've been an independent consultant since 1975, and it's been a creative exercise. to do what I can each day to try and use my interests and abilities to try and bring about public health measures and toxic substances control, asbestos and toxic chemicals. One of the more interesting things I became involved in was this criminal case in Italy. The Italians, unlike the rest of the countries of the world, actually consider death on the job potentially a crime, for which they would put businessmen in jail for causing occupational cancers in their workers or the neighbors of their factories. And the early cases involved dye intermediates in the 1970s, and they put a company doctor and the plant owners and managers in jail for periods of 3 to 6 years because well-known dye intermediates are called benzidine and beta-naphthylamine were causing bladder cancer in over 100 of the workers at the plant. And so then in the 1980s and 90s, cases started to proceed against the Italian managers of a company called Eternit, which had factories all over Europe and South America. And the Eternit company was largely owned by the Schmidt-Heine family. And so at the age of 29 in 1976, Stefan Schmidt-Heine, who's about my age, he was born in 1947, became the CEO, became the chief officer of this multinational asbestos enterprise. And right around that time, a lot of people were asking questions or starting to ask questions, unions, journalists, politicians, neighbors of the factories, about the dangers of asbestos. For the first time, people were starting to realize that asbestos was a very dangerous material, and the industry was suddenly on the defense. And so in 1976, soon after taking over this multinational asbestos corporation, Stefan Schmidt-Heine organized 2 meetings of his managers in order to train them on how to threaten the unions and lie to the public and the media about the dangers of asbestos, because they were suddenly on the defense. They were suddenly having to explain themselves about something they had never been forced to do before. So this was a very interesting and critical time when Schmidt-Heine took over the Eternit enterprise. And so the prosecutors in the Italian case finally did make clear that they were going after the Schmidt-Heine himself. And he was charged, and the trial began in 2009 and lasted until 2012. Schmidt-Heine was charged with creating an environmental disaster and causing the deaths of 3,000 people in Italy from the asbestos mine and the asbestos factories that Eternit operated in Italy, going back to around 1908. And so Schmidt-Heine was charged, and the asbestos cement plant that he ran was, the evidence in the trial showed that there was little or no effort at dust control. I mean, they basically treated Italy as a developing country where the Swiss company could get away with whatever they wanted to as far as asbestos. They weren't going to have to waste money on dust controls, or they weren't going to have to warn the workers about the dangers of asbestos. It's not even clear that they ever did any air sampling in the plant. It was just that careless the way they operated. Another problem with these plants, these asbestos cement plants all over the world, and this is where all the asbestos is used in making asbestos cement, is that they have breakage. In the manufacture of the pipes and sheets, there is breakage, and the broken pipes and sheets cannot be recycled. So what that means is they've got huge amounts of broken asbestos cement pipes and sheets that they have to get rid of. And what they did in the huge plant in Casale Monferrato in Italy, where most of these deaths occurred, was they crushed this stuff up outside the plant. They had a crushing unit, and they would just crush up all this stuff, and then they would shovel it into piles, and then they would distribute it throughout the region for surfacing farm roads and driveways, unpaved roads of all kinds. And so they distributed this mortal danger throughout the countryside in a way that was totally irretrievable. And people are still dying in this town of Casale Monferrato, a town of 35,000 people. One a week gets mesothelioma. It's staggering what these people have dealt with. And most of the cases are people with environmental exposure. They lived as neighbors, they didn't work at the factory, or they were household members of people who did work at the factory, and their brothers and sisters and parents were the people who brought home the dust on their clothes and hugged their children when they came in, not having any idea that they were the vector of this deadly threat. So anyway, that's the background of these cases. The trial court in 2012 announced that they were going to issue their verdict in February, and union people and activists from all over Europe came. We had auditoriums full of people. One auditorium, we had translation into English, and another auditorium, they just broadcast in Italian what was going on, because the main auditorium was full of people who were participants in this case. And Schmidt-Heine was sentenced to 16 years in jail and ordered by the court to pay about 100 million euros in damages to individuals. And the judge, who we didn't know was dying of cancer, stood for 3 hours reading the names of the Italian victims, saying this person gets 70,000 euros and this person gets 50,000 euros. And these were to be interim payments to be paid immediately as an advance against the civil liabilities that the company had accumulated that they owed these people. Schmidt-Heine never did pay that money. He appealed the case, and a year later, the appeals court in 2013 added some additional deaths from Naples and raised the jail sentence to 18 years. And the appeals court said that Schmidt-Heine's cover-up of the hazards of asbestos in Italy delayed the ban on asbestos by 10 years. Italy banned asbestos in 1992. So then the case was off to the next court. Let's see the next slide, Guillermo. So the people would show up in the courtroom, people from the community, and they had very strong feelings, as you can imagine, about what had happened. Next slide, please. So Schmidt-Heine was charged with creating an environmental disaster. Eternit documents had been discovered showing that they were corresponding with their subsidiary companies as far back as 1950 about asbestosis. Then there were these documents from the Bellotti documents. I was referring to some of these before when I said that Schmidt-Heine held 2 sessions to train his managers about how to deal with the public and the unions in 1976. And the way these documents were discovered was that the prosecutors noted that the records showed that the Italian Eternit company was paying hundreds of thousands of dollars to this public relations firm with offices in Zurich and Milan. And the company was called Bellotti, and that this had gone back to 1984, it turned out. And so one day the prosecutors, they sent the police over to the offices in Milan and seized the files. And this is how you do legal discovery in a criminal case. You send the police in and you seize the files. And so they got these incredibly damning documents, including the records of these meetings that Schmidt-Heine held with his managers upon taking control of the company in 1976, where he was told the managers that, according to one of these documents, that some of you were shocked to hear about how deadly asbestos is. We have to make sure this doesn't happen with the workers. And Schmidt-Heine, when he would come, and there were also letters that were sent through post office boxes with the Italian managers that even the secretaries of these managers, the Italian managers, testified they had never seen. So there was a back channel that Schmidt-Heine in Switzerland had with the Italian chiefs of the Eternit operation for certain kinds of high-level communications. And so the rest of this I have told you about the devastation, the broken sheets and pipes, and the 40 to 50 mesotheliomas every month in Casale. Next slide, please. This is the public relations strategy. It's a little hard to read, but basically, one of the Bellotti documents from 1992 explains that since 1984, when we started this job, our strategy has been to limit the discussion in Italy to level 1 and level 2. You see 4 levels in the chart, starting at the bottom. So level 1 is the Italian managers. So and level 2 is the Swiss Eternit Group, which is the company that owned all of these asbestos plants all over the world. But by 1992, that company had been completely cleaned out. It was an empty shell. It existed in name only. And all the money that they got from selling the asbestos factories and mines was in another company, that's level 3, called Anova, which is a company chartered in some canton in Switzerland, where they have absolutely no social responsibilities and nobody's ever going to get any of their money. Even if you win a damage suit in some other country, that it would never be honored. And level 4 is STS, Stefan Schmidt-Heine himself. And the strategy, according to this Bellotti document, was that we will limit the damage and the discussion and the responsibility in Italy to levels 1 and 2, the Italian managers and the empty shell company. And we won't even talk about the company where all the money and wealth has been transferred to, Anova, and we certainly won't talk about Stefan Schmidt-Heine in Italy. We won't even raise his name. And they were very successful. They were patting themselves on the back about how successful they had been doing this in this 1992 memo. And so these are the kinds of documents that came out of the Bellotti files. Very incriminating. Next slide, please. Now, Schmidt-Heine was actually compared by the appeals court judges talking about the case to Hitler, and in the idea that the planning that went into covering this up and avoiding liability for the Swiss company and for Schmidt-Heine himself resembled the meetings that the Nazis held in the beginning of 1942 to map out the industrial process of the genocide of the Jews and the other people they were going to kill. I mean, it was the kind of thing that required a great deal of thought, planning, and organization to do this on the scale that they were going to do it, to kill millions of people. And so this comparison was made, and it even appeared in the Italian newspapers that the judges were making this kind of comparison. Next slide, please. Everyone in Casale knew somebody that had died of mesothelioma, and they had massive demonstrations. The signs they're carrying, the banners they're carrying says Eternit Justice. Next slide, please. So he was sentenced to 16 years in jail by the trial court. A court of appeals raised it to 18 years, and then the Court of Cassation threw out the verdict, overturned the verdict, claiming that the statute of limitations for creating an environmental disaster ran out 10 years after the plant closed. And so it was too late to charge him with these crimes, even though everything in the trial was true. The highest court in Italy, the Court of Cassation, threw out the verdict. But just before that, a few months before that, the legendary prosecutor, Guariniello, filed murder charges against Schmidt-Heine. And there's no statute of limitations for murder. And so the courts, Schmidt-Heine is represented by great lawyers. They appealed this every way they could, and it took 4 years. And finally, the Italian courts decided that they were going to have 4 trials, one in each of the regions of Italy where the deaths had occurred. And and they would be for manslaughter or murder. And some of these cases were murder trials. Now, the first one was a manslaughter trial in Turin involving 2 deaths, and that was concluded in 2019. And Schmidheiny was convicted and sentenced to 4 years in jail. Then in Naples, just a few months ago, the case in Naples came to a conclusion, and in one or two of the deaths, of the 8 deaths involved there, Schmidheiny was convicted and sentenced to 3.5 years in jail. I should also interject here that the Turin case has gone to appeal, and the appeals court has now ruled and confirmed the verdict, the manslaughter verdict in the 4 years in jail and the Turin conviction. And the big case is in a town called Novara, and this is the area where the Casale Monferrato victims live, and there are 392 deaths involved in this case. And the case is going to be ended sometime this year. It's now in the defense part of the case. One of the things that the defendants did was bring in an American expert, Gary Marsh, and Gary Marsh works for this and for this operation called Cardno Chemrisk. And Cardno Chemrisk is this is something that's happened over the last 20 years, is they've set up these consulting operations of toxicologists and epidemiologists and other kinds of industrial hygiene scientists and people like that. And so if some company has a problem with either regulation of toxic substances or liability for people getting hurt with toxic substances that they sold or put out in the environment, and these companies need to have some scientists to defend themselves in court, they call up Cardno Chemrisk for that. And these scientists have actually been called mercenary scientists by David Michaels, who's a very well-known expert on occupational disease in the United States. He was the head of OSHA, the Occupational Safety and Health Administration, throughout the Obama administration. And David Michaels has written a lot about these guys. And he wrote a book called Doubt is Their Product, published in 2008. And in 2020, he published a book called The Triumph of Doubt. The idea being that corporations, whether it started with the tobacco companies, if they've got these kinds of problems with people claiming damages and suing them in court, or people trying to regulate their business, like not allowing smoking in offices, which was very common 30 years ago, they needed to perpetuate a dispute. They needed to create doubt. And so this great tobacco industry memo that came out in the litigation from 1969 was titled, "Doubt is Our Product." And so that's basically the game they play with these mercenary scientists. And so anyway, this guy on the website of Cardno Chemrisk, Gary Marsh, had an impressive list of all the corporate consulting work that he had done for all these different chemical companies and chemical industry trade associations and oil companies and the rest. And a lot of the companies were just described as confidential. The name of the company was withheld on the website. And so when the prosecutors started to introduce this in the trial, they basically destroyed Gary Marsh in cross-examining him as a hired gun scientist. I call them the best scientists money can buy. So anyway, this is the way the game is played, and they are coming to a conclusion in the big trial in Novara, and we'll have a verdict soon. So I think it's going to be hard for the if there was some corruption before with the Court of Cassation throwing out the verdict in 2014, they're going to have a hard time if they've got 3 separate regions having courts that have sentenced this guy, convicted him and sentenced him to jail. That'd be a lot harder for the court to let him off. Even if it's manslaughter, I don't think the statute of limitations is going to help Schmidheiny with these 3 verdicts. And the other thing about these trials is the last 2, the one in Naples and in Novara, are before what's called the Court of Assizes, which is a special court for murder and terrorism cases. And unlike the case in Turin, which had only a judge, the Court of Assizes is configured with 2 professional judges and 6 people who are over 35 years old, chosen off the voters' rolls with no input from the parties in the case. They're just picked almost at random, I suppose, and they are paid as civil servants for the duration of the trial, and they are also referred to as judges. So this is what's, and I am sure that no Italian court is going to look kindly on Schmidt-Heine, no matter how pro-corporate they are, no matter how business-oriented they are. I can't picture any Italian court letting Schmidt-Heine off, having come to Italy and having killed all these people in Italy, making money on asbestos the way he did. Next slide. So I just want to wrap up this part of what I'm talking about, the criminal case. I've always been interested in criminal prosecution, the idea of holding the people who make these business decisions personally responsible for the mayhem and the harm that they create by making their money in such a vicious way. And so I tell people when I speak at schools of public health, I have a 5-part formula for prevention, which consists of information, regulation, compensation, humiliation, and incarceration. And so Gary Marsh got a little bit of the humiliation, I think, just by way of illustrating that. And incarceration is really important. I think the idea of assessing personal responsibility. These are not, I mean, to the people who make them, these are business decisions, but they shouldn't be allowed to totally escape personal responsibility for the very foreseeable death and disease and devastation that these business decisions create. So with that, I will conclude the talk, or what I wanted to say about criminal prosecution. We could either deal with some questions now, or I can just go on and talk about the American legal system, and then we do the questions after. What do you say, Guillermo?
You can go ahead. I think that you can keep on explaining the case.
All right. So you can take the slides down. So now I'm going to talk about the American legal system. The American legal system doesn't do a damn thing about protecting people in terms of criminal prosecution, but it does a pretty decent job of allowing for people to receive financial compensation for certain kinds of occupational, environmental, and consumer product injury. And so I'm going to sort of try and draw you a picture of the legal system. I have been testifying as an expert witness in asbestos litigation since 1979. I've testified in hundreds of trials and explained to juries about how it was that, how long was it known that asbestos was dangerous, and how was that knowledge made available to industry, and what did the individual companies actually do and know about the hazards of asbestos. And that is largely based on internal corporate documents, which have been obtained through the process of American legal discovery. So let me talk a little about that. Now, what I testify about is the public health and corporate history of asbestos. Different experts testify about different things. Medical experts might testify about pathology or epidemiology. I testify about the public health and corporate history, basically about the companies, what did they know and when did they know it, and what did they do about it from the standpoint of preventing asbestos disease that would otherwise be created in the course of their business activities. And the subject of this, I was approached by lawyers in 1976 to start doing this research. The lawyers explained to me that the American system of product liability holds that if you are the seller of a product you have a duty to warn people about what a reasonable person would want to know about the dangers of that product and how they can protect themselves against those dangers. And by warning them, you also provide them with the opportunity to decide not to use the product because the dangers aren't worth the trouble. So, and this is the fundamental principle of product liability. And strict liability holds that if you sell a product and somebody gets hurt, seriously harmed, or gets killed from your product, even if you didn't know, say that this drug caused this kind of a side effect, you're still responsible. That's called strict liability. But if you can prove negligence in terms of a very knowing and willful conduct on the part of the company selling the product, well, then it gets more serious in terms of the kind of damages and payment that can be awarded to the victims who are bringing these cases. The seller of the product is held to the standard of an expert on the hazards of the product. The courts presume that if you can read patents, you can read pathology papers. You ought to be able to be basically familiar with what's known about what it is that you're selling, especially if it's something like asbestos that has a body of medical and scientific literature that's easily available in the medical libraries. And you don't have to create it. You just have to go and look it up. So with this as a background, there are hundreds of thousands of cases that have been resolved. There are hundreds of thousands of cases still pending in American courts. There are 3,000 people a year that die from mesothelioma in the United States. Many of them would have a case if they could find somebody to sue. A lot of the companies have gone into a bankruptcy reorganization in order to stop the lawsuits and have created separate funds in order to pay off the victims some fractional amount of what they would otherwise be owing and have to pay. But even so, there are plenty of other companies that remain defendants. Hundreds of companies, probably 1,000 companies, have been defendants in asbestos litigation in the United States. Let me just see a little bit what we have. The cases are usually brought for mesothelioma or asbestosis. It's a cause-specific disease. Asbestosis, it has to be pretty disabling for a lawyer to take a case. In the beginning of the litigation 40 years ago, people with minimal disability but definite signs of asbestosis could bring a case. Now you wouldn't be able to find probably a court that would convene a trial for a case like that. It's kind of like, come back when you're dying, kind of is the attitude the courts have. But there are so many of these cases just for the people dying that there's a certain logic to that. Mesothelioma cases are the easiest cases for the lawyers to win because you don't get mesothelioma from smoking or anything else that we have, that's commonly found in the world. Whereas, if they take a lung cancer case, most of these working class guys or working people smoked at some time, and so it's a more difficult case to convince a jury that more likely than not, that's the standard that you have to prove. More likely than not, the product, if not for the product exposure, you wouldn't have got the disease. So there are people who smoked and got lung cancer who are still entitled to compensation because studies of insulation workers have shown that they have 5 times the rate of lung cancer as smokers do. So that means 4 out of 5 of these guys dying with lung cancer wouldn't have gotten lung cancer but for their asbestos exposure. So this is just by way of giving you an orientation of what these trials are all about. These are jury trials. The people who decide whether the company or companies, there are many times there are multiple defendant companies because the worker worked with lots of different products, and maybe multiple companies made the asbestos gaskets or the asbestos brake pads or insulation or other asbestos materials, asbestos cement pipes that the worker was exposed to. So there may be multiple companies. And anyway, the liability, whether or not the companies have to pay, is determined by a jury of ordinary citizens. And the jury is, and the judge, the role of the judge is to decide on the admissibility of evidence. And so whenever there are objections to the introduction of certain evidence by one side or the other, the judge has to make a ruling on whether that evidence can go in or not, or whether there need to be some limitations. Like, lots of times when I'm testifying, there'll sometimes be an objection by the defendant companies about something I say. And so then the judge has to decide whether or not to rule that the jury should disregard the last sentence I had said based on some legal reasoning. Well, it just depends. Now, the compensation is for economic loss. That's the medical costs and the lost earnings. So if you die 3 years before you would have stopped working, so 3 years of salary of income from those years is part of your economic loss, or your family's economic loss, if this is brought as a wrongful death case by your family. If you die before the case goes to trial, the same case can be brought as a wrongful death case. And and in addition to the lost earnings and the financial costs, is pain and suffering. And that's what the jury, that has as much money as the jury says it is. That is left to the discretion of the jury. And these days, it's not uncommon for a jury in the United States, if they find the companies responsible and it's mesothelioma or lung cancer and the person's dying, they may award several $1 million in pain and suffering to that individual. And in addition to all of that, if it can be shown that the company behaved in a way that was willful and in total reckless disregard for the health of the people who were exposed to the risk, the jury may be allowed by the judge to additionally impose punitive damages on the defendant or defendant companies. And in one case I was involved in, there are a lot of people from Iran who came to the United States and moved to Los Angeles. And so periodically I'll have these Irani guys bringing a case in LA. And one of these guys, his exposure had been in the 1970s, building an oil refinery that was being built in part by American companies. One of these companies was called Fluor, F-L-U-O-R. And so the Fluor company, which is a big construction contracting company, building things like oil refineries, was being sued in Los Angeles by this Irani guy who was an American citizen and had moved here 40 years ago, and would develop mesothelioma, and he was suing this American company for not having protected him against the asbestos they were installing in that plant in Iran. And one of the pieces of evidence was showing that they were deliberately using asbestos insulation in 1976 in building that refinery, a year after asbestos insulation had been banned in the United States as an air pollution hazard by the Environmental Protection Agency. So they were using something that would have been totally illegal in the United States, and they were going to Iran, and they were even trying to buy up the insulation from a Japanese company that was ceasing to make the asbestos. This is what the documents we found in legal discovery indicated. And so, and those documents were introduced during my testimony in trial. And so the jury came in with a verdict, I think it was a $5 million verdict, of which Fluor's share would have been $2 million. And then the judge said, okay, did they think that Fluor had acted in a willful and malicious way? And the jury said yes. And the judge said, okay, now go back and figure out how much they should pay additionally in punitive damages. And Fluor immediately settled that case, paying an undisclosed sum to the plaintiffs in that case and in another case before the jury could come back with a number. So punitive damages has quite an effect on some of these companies and getting them to be reasonable about settling cases. Now, the process of pretrial discovery, I've just lightly touched upon, but basically companies are supposed to produce relevant documents before the trial. When they're sued, it's relevant to the question of what did they know about asbestos and when did they know it? Did they have any workers' compensation claims for asbestos disease among their own employees making their asbestos products? Do they have any records of internal memos about warning labels, about how they're dealing with regulatory agencies like OSHA or EPA? There are all kinds of corporate documents that emerge. There are industry trade associations. Some of the most damning documents were trade association documents, where groups like the Asbestos Textile Institute would share information about the hazards of asbestos, just like the tobacco companies probably did, because it was a problem they all had. It wasn't something they wanted to tell anybody about, but among themselves, they were trying to figure out, well, how do we deal with the fact that we're getting more and more of these workers' compensation claims, and we're afraid that we're going to have to start dealing with all kinds of public pressure or government pressure any day now, or union pressure. So anyway, these documents were extremely damning. I've written about all of this. My doctoral thesis was completed in 1985, just a few years after I started testifying in these trials. And my doctoral thesis has been published as a 900-page book that Guillermo mentioned. And every line in this book has been fact-checked by the lawyers and scientists for the asbestos companies. And every once in a while, they point something out to me that's ambiguous or even incorrect, and I've corrected it, and it's now in its 5th edition. And every time they do that, I put their names of the defense lawyers who gave me the correction on my acknowledgments page in the book. And we also have something called premises owner liability. Similar to product liability, the owner of industrial premises, the owner of like oil companies and power plants, are big industrial premises, and many of these premises owners subcontracted the work of doing the asbestos replacement. And I think one of the things that I'm starting to see documentation of, but it's not conclusive yet, it looks to me like the big oil companies started subcontracting all the dirty work of removing the asbestos whenever they had maintenance shutdowns of the refineries, and they had to bring somebody in for a couple of months to remove and replace the insulation and the gaskets and all that. They would bring in some other company like Halliburton or Brown and Root. They'd bring in some contracting company, and that contracting company would subcontract the different jobs to local companies at the cheapest price. And so the contracting workers weren't protected, but the oil companies or the big the owners of these industrial premises knew that they'd be gone in a month. They weren't going to get occupational cancer or asbestosis after working there for a month or two. They'd get it later. And the companies also realized that they could be sued by those workers because they didn't have an employer-employee relationship with the workers who were affected. They were working through an intermediate party. So they realized they could be sued if those workers eventually got asbestos diseases. And they bought insurance for that, premises owner liability insurance. And they bought so much of that insurance that when people tried to change the law in the United States to shut down the courts to the asbestos victims and create a fund that industry would contribute to for 25 years, the oil companies opposed it because they were fully insured under the present system, and they weren't interested in putting money into some fund as an alternative. So that's just an illustration of what goes on. But in any case, with premises owner liability, if you own, say, an oil refinery, and you bring contract workers onto your site, generally the laws in the states hold that you have a duty to warn and even protect those workers against foreseeable hazards, hazards that you know exist in your industrial site. When you're bringing people onto that site, you know where the hazards are, you know what the hazards are. You should warn them about that. And if you don't warn them, they can sue you if they get hurt. So that's the basis of premises owner liability. There's also, in case of family members of the workers, people who get mesothelioma from the dust the worker brought home on his clothes working at the oil refinery. The worker couldn't sue the oil refinery if he worked for the oil company, because there's workers' compensation laws that very much limit the amount of compensation that the worker could get. And he has to apply through this administrative system of workers' compensation with very limited amounts of financial recovery. But if the family member gets mesothelioma, say from the dust the worker brought home on his clothes, the member of the family can sue the company because the family member doesn't have an employer-employee relationship with the company. And workers' compensation doesn't serve as a barrier to protect the company from such lawsuits. And the negligence of the company in allowing the worker to go home with asbestos dust all over his clothes day after day can be brought into the court case, and the jury can award whatever damages it chooses to at the end of the trial. When I testify in these cases, basically the testimony is in two parts. First part is about my qualifications. How is it that I'm an expert in whatever I'm an expert in? And what's my professional background? And what studies have I done to become knowledgeable about the public health and corporate history of asbestos? And then separate from that, then I tell them the story, starting at the beginning, the earliest published articles about the hazards of asbestos, the publicly available knowledge that the companies could have availed themselves of if they simply took the trouble to look it up in a published form in the libraries, basically. You could walk into a medical library and in 1/2 of a day, you could learn all about the dangers of asbestos, enough to scare you to death at any time since the 1930s, based on what was easily findable in medical journals, medical textbooks, and medical abstracting publications, all of which was very easy to look up. And if you didn't know how to do it, there were medical librarians right there in the medical libraries who could show you. All you'd have to do is ask them, how do I find out whether asbestos is dangerous? Is it hazardous to workers? And the librarian could show you everything. I mean, the books about occupational diseases, I collect these old books because part of my research was finding all that stuff. And so, I have this library of articles these are my collection of books. It's as good a collection as any library has of old books on occupational diseases. And if you went to a library to look up these books, you would you would find them one right next to another. That's the way they're set up. Okay. Now the way the plaintiff's lawyers get paid is they charge contingent fees, and the contingent fee. I seem to have handled the computer in a way that I don't see you guys, but anyway, I hope you can hear me, and I can hear you.
Yes, we can.
Okay, I can hear you fine. Thank you. So the contingent fee arrangement is that the lawyers don't get paid anything until the money starts coming in. And the general agreement is that the lawyers take something like 35 or 40% of the damages that are ultimately recovered in a successful case. And if the case fails, the lawyers absorb those costs, and the plaintiffs, the victims, still don't have to pay anything. So those are the conditions that enable some of the poorest workers in the country to be represented by some of the best lawyers in the country. Now, these lawyers also run television ads, and so they've added one word to the public vocabulary through all these television ads, and that word is mesothelioma. Trying to find additional cases by television ads. I want to mention also that talc, Sean is here, and he's done a lot of important work in identifying talc and talcum powder as a serious danger that because of its contamination with asbestos. And it takes high-powered microscopes, as you could see from his earlier presentation in this series. And so these cases have been added to the asbestos litigation. It's also been shown that talc, or rather that asbestos, is associated with ovarian cancer. And so a large number of the cases in the talc cases brought against Johnson & Johnson and R.T. Vanderbilt and Colgate have been brought by women with ovarian cancer. But there have also been quite a number of people with mesothelioma, and there's been at least one report in the literature a couple of years ago of 75 deaths from mesothelioma in individuals with no history of other asbestos exposure, except that they use talcum powders. The medical and scientific literature established by the 1970s that there was no safe level of exposure to asbestos, that even 1 day of exposure with experimental animals, with rats breathing asbestos dust, as little as 1 day of exposure could cause lung cancer and mesothelioma in rats that do not get those cancers absent the asbestos exposure. Rats, in other words, the unexposed group of rats didn't get those cancers at all. And the rats who were exposed to asbestos for as little as 1 7-hour day, there'd be 1 or 2 in a group of about 40 that would develop lung cancer or mesothelioma. And with longer exposure, the number of the animals that developed mesothelioma and lung cancer was increased. And of course, these were non-smoking rats. That is to say that the asbestos alone was capable of causing the lung cancers that those rats got. You know, today asbestos is a criminal industry. It's been a criminal industry for a long time. You know, I just hope, you know, it should be in a class with the tobacco industry, which the World Health Organization has said should not be treated like every other industry by governments. The government's only purpose in talking to the tobacco industry is to shut it down, but not to endlessly argue with them about the various issues of doubt that they want to raise in delaying government action and regulation. So with that, I'll conclude. I've been going for an hour. It's a long time, but we had a lot to cover. And I hope this has been of some interest to you. Yeah, any questions you're welcome to.
Yes,
ask.
we have some questions right now.
Muchas gracias, Barry.
Yes.
Y le cedo la palabra a Renata Cortés. Ella es antropóloga médica y va a estar encargada de la sesión de preguntas y respuestas. Adelante, Renata.
Muchas gracias, doctor Berry, por toda la explicación que nos ha dado sobre el tema legal y el caso específico de Italia, y sobre todo la actualización de cómo va el caso contra Smith-Heine. We have 3 questions right now. The first one is, in Mexico, we have our own Smith-Heine. His name is Carlos Slim, the owner of Grupo Carso, who bought Elementia this year. And he is also a philanthropist and is very close to the president of Mexico. Thus, pointing out pointing or calling him could bring an offensive that is very difficult for a Mexican movement to avoid. So the question is, do you consider that the path of the movement against asbestos in Mexico should focus on a ban that does not go through the humiliation in calling out of these actors? What do you think?
I think it's very useful to point to individuals like Carlos Slim is the richest man in Mexico, right?
He's the richest in Mexico and one of the most rich in the world.
Yeah, so he doesn't need the money. And, you know, I think it would be very useful. I don't know about the situation in Mexico, but in most countries, I think it would be useful to start getting personal about the fact that this man has the power to save countless lives by simply converting this business to a non-asbestos fiber cement business, as they've already done in Colombia. You've got a very compelling argument, and at the same time that some people are saying that, other people might be saying, "Oh, look at the Schmidt-Heine case. Maybe we should have one like that over here for Carlos Slim." I think both of those tracks would be worth pursuing. I think the idea of assessing individual personal responsibility is very important. And here's somebody that everybody knows, and he should feel some heat for what he's doing. He has less reason than anybody could have to go on with such a deadly business, such a criminal enterprise. He doesn't need to make money doing stuff like that.
But yeah. Dr. Castleman, the question is more, is there a way of moving forward on these initiatives without creating public humiliation for billionaires in charge, like this guy, like our own Trump? You know, is there a way to do this without sticking the poker in the rich guy?
Oh, well, if that's the question, well, then you just had the usual methods of going to the government and saying, this is a public health disaster. Dozens of other countries have already banned this stuff. Look at all the people that are dying from it here that Guadalupe has documented. We really need to do something. It's a public health, this is a public health catastrophe in motion. Of course, you want to do that anyway. I'm just saying, additionally, serious thought ought to be given to bringing it out in a very personal way, in some manner through the media.
Okay, thank you. The next question is related to the previous one, and it's, can you tell us more of what you have learned regarding the uphill battle Mexico faces?
Regarding what?
The battle that Mexico has been facing, when you mention about the work you have done in Mexico, or the work you know that people has been doing in Mexico.
Well, I mean, my work in Mexico was long ago, but I started to be concerned about, when we started regulating asbestos in the United States in the early 1970s, at some point I became concerned that the dirty industries would go to Mexico. And sure enough, as the government, the US government kept import statistics on asbestos textiles as an individual import commodity. And you could see this dramatic rise of increase of asbestos textiles coming in from Mexico, Venezuela, Brazil, and Taiwan starting in 1970. And by 1973, it was quite impressive, most of it from Mexico. And subsequent investigations with congressional offices, I was able to find out that the exporting company was a company called Amatex, which was a US-based company with a bad history in the United States. They had a dirty plant in New Hampshire where a lot of people had gotten asbestosis. And it turns out they had built a new plant in Pennsylvania in 1967. And in 1972, they shut it down and moved it to Mexico. And so I wound up in Agua Prieta on the border with Douglas, Arizona in 1976. And I saw the asbestos hanging off the fence. It was just like, it was like moss hanging off the fence, white moss all over the fence. You could hardly see the peligro sign that was also on that fence. And so I told people in the media about that, and eventually journalists started doing stories about that. And the company also had another plant in Juarez. And then there was publicity. A Texas radio station television station started doing interviews and questions about what they were doing in that plant in Juarez. And this was in 1977. And a lot of the workers quit because nobody had ever told them anything about the dangers. You know, meanwhile, the company was telling the workers, shut up and do your job and don't ask a lot of stupid questions about asbestos. And so that was the company, the American company never submitted to an interview. I call them death merchants, but they never agreed to be interviewed because there was no innocent explanation for what they were doing on the Mexican border with the United States. And one of the people I contacted was a guy named Efrain Gadea, who worked for the Mexican government, who actually mailed me a list of asbestos companies all over Mexico. He was interested in looking into this question of whether these dirty industries were being exported to Mexico now that they were coming under regulation in North America, in the United States, I mean. So this is just by way of background. I mean, I quickly became concerned that if all we accomplished with creating our regulations to protect workers and the environment in the United States would be to drive these dirty industries across the border, we might kill more people than we saved. And from a public health point of view, that was totally unacceptable. And so that's why I started working with people. And over the years, I've worked with people in over 25 countries on the ground, trying to do something about the problem of asbestos and the challenges it creates, trying to create awareness, trying to create government regulation, trying to get compensation for victims, trying to get media coverage, things like that. And lots of times a foreign expert can say something that the local experts could say, and the media will cover the story in a way that they wouldn't if the local doctors and other people within the country were saying the same thing. So being a foreigner, being a foreign expert, so-called, sometimes enables me to do these kinds of things to raise public awareness around the world.
Gracias, doctor Berry. Otra pregunta es, ¿existe alguna regulación para la responsabilidad de las compañías del asbesto en Estados Unidos? ¿Se basa en algún criterio ambiguo de alfabetismo en salud? Cuando se implementaron los sellos en productos alimenticios en México, uno de los argumentos contra esta estrategia fue que la gente no entendería el mensaje de salud que se quería enunciar o que se quería transmitir.
Well, the idea of warning people about the dangers of asbestos products is pretty simple. You basically want to use words and symbols that ordinary people can understand, and you want to keep it very simple the way you say it. And so I have in my book an example of the types of warnings that have been used. One of these warnings is the warning that was placed on asbestos products by the British asbestos companies after consulting with a firm that had done work for the tobacco industry. And so what they came up with was this warning. Asbestos, observe the safety rules. Take care with asbestos. This is what the public relations people came up with as a warning label. And this is what they wanted to avoid. This is the label. This was the posters that were put up in schools in Puerto Rico, made of asbestos cement sheets. And the teachers were. So you see the two very different kinds of warnings. All right? But it's not that hard to warn people about asbestos in a way that they're going to understand. I hope I've answered your question.
Gracias, doctor. Otra pregunta. Sobre los casos que usted nos ha comentado, sobre toda la experiencia que tiene acompañando el litigio de estos casos, ¿existieron algunos donde las causas de muerte no eran clasificadas como asbestosis y se tuvo que probar de forma posterior?
Well, in all of these cases, they have to prove that more likely than not, the asbestos exposures that the defendant companies were responsible for caused their disease. So there might be a guy who worked with asbestos insulation for 10 years and did a couple of brake repairs. And among the companies they sued were the companies that made the brakes, the 2 brake repair jobs that the guy did on his own car. Well, the jury might find that it's unlikely, extremely unlikely, that the brake repair exposures significantly contribute to his development of cancer from asbestos. Even if he got cancer from asbestos, it wasn't from the brakes. So you always have to establish that to win a case. You have to show product identification. Lots of times that's not easy. If you've got a guy who worked with certain products 30 years ago and you don't have any coworkers, first of all, the guy might not be able to remember the products he worked with, and the employer that he worked for might not have any records. You might not be able to find any coworkers who could add to what this worker remembers. And so you might lose the case simply because you can't prove product identification to the satisfaction of a jury. In one case, the worker died before he was able to be deposed. He told his lawyer about his exposure history, but they weren't able to schedule a deposition and create a legal record of what his recollection was in order to put it into the case before the jury. And so that case lost, even though his testimony would have established that he had that exposure. He died before he was able to create that record. So these are the kinds of things that can happen. And of course, especially with the lung cancer, the defendants might be able to convince the jury that the guy smoking was the cause of the cancer, and the asbestos should be discounted as not being more likely than not to have played a critical role in the development of the lung cancer.
Gracias. Otra pregunta es, ¿existen leyes en Estados Unidos que regulan las concentraciones de asbesto dentro de las fábricas? ¿Y a cuánto tiempo de exposición se han visto las repercusiones de neoplasias? Bueno, creo que de esto habló un poco antes, ¿no? Que no era necesario una exposición muy alta o muy duradera, sino que puede ser un corto tiempo, los experimentos con ratas han probado que las exposiciones cortas incluso pueden provocar cáncer.
Well, just by way of the regulations, there are OSHA regulations, Occupational Safety and Health Administration, regulations for the concentration, the limits of concentration of asbestos in the workplace. And OSHA says that the permissible exposure limit, as the law refers to it, is 1/10 of a fiber per cubic centimeter, or equivalently 100,000 fibers per cubic meter of air. And ordinarily, a worker breathes about 1 cubic meter an hour if he's not very physically active at work. And that is the maximum allowed concentration under the law in the United States and in many other countries. This is not safe. It's recognized that a number of people will get cancer, maybe 5 to 10 out of 1,000, according to the epidemiological studies. But there are limits to how low the exposures can be set. In this case, the air sampling method that's used to monitor worker exposure is not considered reliable for 8-hour samples at levels of exposure below 0.1 fibers per cc. So the method of analysis is what limits the government in lowering the exposure limit further. So this is, the government recognizes that people will get cancer even at that level of exposure, but this is as low as OSHA is able to go in setting exposure limit. This is one more reason why asbestos should be banned. You're still going to have asbestos exposure when people do repairs on structures that contain asbestos or cars that contain it. That's going to go on after you ban asbestos, but at least by banning asbestos, you stop the continued addition of asbestos to the living environment and the working environment.
Gracias, doctor. Y última, bueno, es una consulta. ¿Sí podrías recordarnos el nombre de tu contacto en México en los años 70, esta persona que estaba en el Ministerio de Salud?
Yeah, his name was Efrain Gardea.
Efrain
Gardea, Gardea.
Gracias.
Efrain, Efrain. I've sent a name to Guadalupe, and she said she'll see if she can find him between now and November, if he's still around.
Ah, gracias.
He was a young guy then, so he might still be living.
Okay. Otra pregunta es, ¿cómo es que Italia logró articular una demanda desde 4 regiones al mismo tiempo? ¿Existe una organización sólida a nivel nacional o entre organizaciones locales como AFEVA?
Yes, there are organizations in Italy, and there are organizations of asbestos victims that try to get the courts and the legal system to be responsive to the needs of the victims. So yes, there's a group like that in Italy, a similar group in France and in Australia and many other countries. I think that organizing the asbestos victims is something to consider in Mexico as well. Start trying to locate these people and try to get them some kind of justice.
So, esto ayudó a que se pudiera generar una demanda y se pudiera llevar a juicio a Schmidt-Heine otra vez.
I don't understand. Say it, explain.
Sí, si estas organizaciones sociales o estos movimientos sociales coadyuvaron o ayudaron a que se pudiera organizar una demanda colectiva en términos jurídicos o legales o para poder tener un juicio contra Schmidt-Heine. O no necesariamente tuvieron un papel relevante estas organizaciones o estos movimientos sociales en el juicio contra Schmidt-Heine.
Well, they organized people to come to these trials, and they would hire buses to bring people to the trials. The asbestos victims group in Brazil brought a legal case to challenge the law that the asbestos industry had gotten enacted decades earlier, saying that controlled use of asbestos, as they call it, is okay. And this was challenged in the courts because the Constitution, after the dictatorship, the Brazilian Constitution of 1988, created a right to a safe environment, among other things. And so on that basis, the asbestos victims of Brazil, the asbestos victims group, challenged that law and got the Supreme Court to overturn the law, and that summarily banned asbestos. So Brazil is the only country where the Supreme Court shut down the asbestos industry, and it was in response to this lawsuit that was brought by the asbestos victims group.
Muchas gracias, doctor Berry. No tenemos más preguntas. Ha sido un placer verlo nuevamente y nuevamente gracias por todo el conocimiento que nos ha compartido esta noche. Me despido.
You're welcome.
Perdón,
if you have other questions, you're welcome to get in touch with me by email.
Okay.
And I'd be happy to respond in any way I can. Very important to do something about this in Mexico.
Ahí estaba levantada la mano del doctor Alejandro Cabello. Un segundo. Just a second. ¿Será que podemos abrir el micrófono del doctor Cabello? ¿O lo tendrías que abrir, doctor?
Ya no veo a Alejandro, creo que se fue. ¿O sí está ahí?
I can't hear what the question is.
He's going to type the question. Sí, por favor.
El micrófono.
Listo. Ya está activado, doctor.
Sí,
Ya está activado.
Sí, gracias. Sí, pues digamos que también, bueno, primero que nada, muchas gracias por la plática y por todo lo que nos ha comentado. Precisamente lo que ha comentado de la documentación de casos que ha hecho la doctora Guadalupe también lo que ha promovido hasta cierto punto es la creación, algo similar a lo que se hizo en Italia y en Brasil, como usted lo había mencionado, a través de los sindicatos de trabajadores, el Registro Nacional del Mesotelioma, como en Italia, en el cual no solamente se creó, o pues el objetivo no solamente fue hacer vigilancia epidemiológica de los casos que fueran apareciendo, los casos e incidentes, sino también crear estrategias de prevención y promoción de la salud entre los trabajadores y las trabajadoras, y crear fondos de pensiones que provinieran de la recaudación que se hiciera por parte de las empresas, para que ese fondo sirviera para la compensación tanto de los trabajadores, de los ex trabajadores, como de las familias, y también promover protocolos de investigación que ayudaran al diagnóstico de los casos de mesotelioma. Aún así, un colega italiano, el año pasado hubo un congreso en Brasil, un seminario, en el cual dice que a pesar de la estrategia activa de vigilancia epidemiológica, que tienen 4 centros principales, el más grande pues en la región de Milán, aún así se considera, o ellos consideran en Italia, que hay un subregistro de los casos de hasta del 50%, entre 40 y 50%. Entonces, considerando estas dificultades hasta para rastrear los casos de las personas que potencialmente pudieran haber estado expuestas al asbesto, y como bien dice, ¿no? El periodo de latencia es muy largo, muchas veces hay sesgo de memoria en las personas, no pueden identificar los productos o los trabajos en los cuales se encontraron expuestos al asbesto. Mi pregunta es, a pesar de que existe este movimiento en Italia y en Brasil muy fuerte social, ¿qué estrategia gubernamental similar a este Registro Nacional del Mesotelioma que Italia propuso, y en Brasil tiene otro nombre, pero básicamente hace la misma tarea,
¿Qué tipo de estrategias se podrían implementar similar aquí en México? En México, como usted lo sabe, pues no hay un registro, ni siquiera hay un registro nacional de muchas de las enfermedades, y en el caso de las enfermedades ocupacionales, solamente una institución, que es donde trabajaba la doctora Guadalupe, pues las lleva. Y ha sido muy difícil documentar los casos de mesotelioma y ponerlo como un problema de salud, porque precisamente las compañías a las cuales se les imputan los casos de mesotelioma dicen, pues en el IMSS, que es quien tiene, o el Instituto Mexicano del Seguro Social, que es la institución que regula y que registra estos casos de mesotelioma, pues no tiene más que 10 en 75 años de historia del instituto. Entonces, como que es un problema de salud pública si no existen esos casos. ¿Hay alguna otra forma, alguna otra vía como para promover la creación de este tipo de iniciativas que usted haya conocido en otra parte, fuera del contexto europeo y latinoamericano? No sé si en Estados Unidos eso exista o se haya impulsado. Muchas gracias.
Well, I didn't say I didn't say anything about unions, and I think it's very important to try to work with unions. Unions have been extremely important in bringing about the improvements that we've had in the countries around the world, especially the unions of workers who are exposed to asbestos or whose members used to be exposed to asbestos. I think it's very important also, the unions can help you find cases of individuals who've developed cancer from asbestos or asbestosis. They can help you find those individuals. Those individuals may be willing to go public with their concerns and needs and demands. So I think working with unions is certainly something to give serious thought to. And another thing that you make me think of is the idea of a cancer registry, a mesothelioma registry. In Australia, they have a mesothelioma registry where they would track down, they would have a social worker track down in every diagnosed case of mesothelioma, ask the individual how that person might have been exposed to asbestos. And by creating this kind of data, without naming the individuals, just publishing stuff by the registry, that, you know, we have found that we had so many cases of mesothelioma last year, a certain percent of them were people who were exposed as mechanics, repairing cars and trucks. A certain percentage of them were construction workers dealing with asbestos cement sheets and pipes. And there will be other people who had minimal exposure, which was able to be determined by a thorough questioning of these individuals with mesothelioma. And it's the minimal exposure cases, the household contact cases, the neighborhood cases, the environmental cases, which a thorough investigation would reveal in questioning these individuals with mesothelioma. And you can start to create information that can then be used for public pressure campaigns saying, look at all the thousands and thousands of people we have who have this kind of exposure or that kind of exposure, and look at what it can do to you. So we really need to start regulating these industries. We need to start putting cancer warnings on these products. We need to start assessing some kind of liability for the economic harm that these companies are externalizing to society. They should have to pay for some of that. So these are the kinds of things that you should consider.
Muchas gracias, Barry.
Muchas gracias.
Quisiera de pronto complementar la pregunta que hizo Octavio respecto de la humillación, que de pronto yo lo llamaría en español como exponer públicamente a estos actores, exhibiendo pues todos los errores y fatalidades que ellos cometen con sus empresas. En el caso colombiano y en el caso personal, como artista acá en Colombia, había un gran interés de Smith Heine de crear un museo muy importante para América Latina en Río de Janeiro. Y digamos que los artistas colombianos hacían parte muy importante de esa colección de arte. Artistas políticos muy importantes, no solamente de Colombia, sino de América Latina. Cuando descubrí que Smith Heine estaba detrás de este museo, pues fue una cosa horrible para mí, muy difícil de entender cómo de una parte el arte estaba siendo financiado por un filántropo que en Italia a su vez estaba siendo condenado por la muerte de más de 3.000 personas en Casale Monferrato. Sí tomé una decisión muy clara y fue escribir unos artículos donde expuse esa situación, tal vez con un enorme costo personal porque la gente del arte no me quiere mucho en mi país, pero sí entendí después de ese proceso que fue muy importante esa exhibición pública, esa exposición pública de Smith Heine, porque al menos la comunidad artística colombiana entendió la situación y eso ayudó a que el fenómeno del asbesto en Colombia, al menos en el sector del arte, y creo que trascendió esos espacios, le prestara atención al fenómeno de, el asbesto en Colombia. Y yo creo que sí es importante utilizar esos espacios. Por ejemplo, el principal magnate del sector de fricción en Colombia está muy vinculado al arte también. Su esposa es la directora del Museo de Arte Moderno de Bogotá. Y en algún momento, antes de la prohibición, pensé en hacer una intervención en una de esas galas muy importantes que realizan los museos, mostrando el efecto tan terrible que estaba teniendo el uso del asbesto en los trabajadores de esa empresa, gracias a una investigación que hicimos con el doctor Arthur Frank. Y hay una cosa muy importante, siempre el sindicato me dijo que si hay algo que le preocupa a estos grandes hombres de negocios, más allá del dinero, es cuidar su imagen. Y si nosotros logramos hacer daño a esa imagen, mostrando las verdades que hay detrás del uso del asbesto, creo que conseguimos audiencias. Más allá del interés de hacer ataques personales, es como estas figuras públicas que ocupan lugares tan importantes en nuestra sociedad, al ser exhibidas, mostrando todos los daños que causa y la negación que ellos tienen de las enfermedades, de los efectos del asbesto, tiene un enorme efecto muy importante en la sociedad y por eso me parece que es un camino válido y la recomendación que hace Barry es igualmente muy importante y es algo que no podemos negociar. Si encontramos esas personas que son tan importantes escondiendo crímenes, me parece que hay que, como sociedad civil, exhibirlos y mostrarlos a la opinión pública. No sé si haya más preguntas. O Barry, ¿quieres complementar algo?
I just want to say one more thing in response to that, and that is that back to the 5-part formula and the idea of humiliation as an element of social change and progress in public health. I think that Carlos Slim might find it a little uncomfortable to be called a death merchant publicly. And I'd certainly be happy to use that expression to describe him if the media were to call me up and ask about his asbestos business. But I imagine there are people in Mexico who can raise the same kind of charge. What's he doing running that kind of a dirty business?
Bueno, Renata, creo que no hay más preguntas, ¿no? Bueno, no queda sino agradecerle muchísimo a Barry Castleman por su presencia. Gracias a todos los participantes, al doctor Cabello, creo que nos acompañaba la doctora Aguilar, Sean Fitzgerald. Y nos vemos el próximo miércoles 14 de septiembre, donde tendremos la presentación de la doctora Hedy Kindler de la Universidad de Chicago, una de las reconocidas expertas oncólogas en el tratamiento de mesotelioma en el mundo. No es nada más por el momento y muchísimas gracias a todos. Gracias, Barry.
Gracias, Barry.
Okay, thanks and good night.
Buenas noches. Buenas noches.
Buenas noches.
Buenas noches.
Buenas noches.